Callender versus Lawson. That is the name of a United States Supreme Court case that was decided back in 1983. I'm the Lawson part of the title of that court case, Callender versus Lawson. Callender is the then chief of police for the city of San Diego, who was the other party in that particular lawsuit. And of course, San Diego is a fairly affluent community. The case started very innocently. First day that I flew into San Diego, I meet some people just by chance. They invite me to a party. I go to the party. Party finishes, and it's a beautiful San Diego evening, so I decide I'll walk home. Start walking home, get halfway there. It's late at night. It's quiet. The crickets are probably chirping. All of a sudden, boom, a sheriff's car falls out of a tree. Sheriff comes out, and of course he's got, guns sticking out of him. He's got antennas sticking out of him, all that sort of thing. And he wants to know, do I have any identification? And of course, I being the curious type, I asked him, well, identification, why do I need identification? And he goes, you can do it the hard way, you can do it the easy way. Conversation escalates. Next thing I know, I am sitting in the county jail. I'm sitting in the county jail charged with a violation of 647E, which was the California ID law. And as I get further and further in this whole thing, what I discovered is that anytime that I was anywhere in San Diego where you had black people who were sitting around talking, or brown people were sitting around talking, or young people were talking, the conversation would take 3 minutes before it got around to everybody had a police ID story. Everybody had a police ID story, which seems to be like every other day of their life, they're being stopped for ID. And so I'm listening to all of this, and I'm saying, well, this just happened to me, and it's been happening to all you people. Why doesn't somebody do something about it? And that's, of course, when, everybody starts looking down at their feet, and everybody starts going with the hemming and the hawing, and all the reasons that this sort of thing had been tolerated. I said to myself and to anyone else that would listen, it strikes me that this kind of conduct, in addition to being a tad inconvenient, is also unconstitutional. And so I took the case to court and did everything I could win the case. I lost. Okay, so fine. You win some, you lose some. No sooner than I got out of jail for the first infraction of 647, the California ID law, then boom, another cop. Same question for ID, same interchange. And this one I didn't end up getting arrested for, but they held me for a certain number of minutes, hours, whatever. And this just kept on happening to me over and over and over again. Okay, so finally, about 15 times in 18 months, in all sorts of different configurations, I would be sitting in a restaurant. I would be, again, the inveterate pedestrian, which means I would be walking to one place or another. Sometimes I would be doing things as simple as I would be living in La Jolla, and I would be going from the front door to the curb or something that's and boom, they would hit me. So I took about 18 months to get 15 different occasions where they had stopped me for ID checks, 15 occasions where I had taken notes and got the policeman's badge number, written down a simple description of what was taking place, and I decided to take them all to court. Take them all to court to challenge as to whether this kind of conduct was constitutional. What I started out with was the assumption that I could basically get some kind of legal assistance, because like anything that you do in this country that involves law involves money. And so if you don't have a whole bunch of money, which I did not at the time, what you're obliged to do is to come up with some kind of legal assistance. So I started off by getting a list of all the biggest law firms in La Jolla, in Del Mar, in San Diego, all the places where people have lots and lots of money and should have, an interest in investing in or contributing something like this. And I went through this series of meetings where I'm going to see all these big-time lawyers and all these big-time offices with big-time secretaries and big-time mahogany desks. And, of course, all of them said some variation of no way. So the second thing I figured was, well, there's got to be all sorts of local organizations that should be like indignant and outraged at this violation of constitutional protocol. And so I went around to all the local, do-gooders who are supposed to do this sort of thing and told them, why can't we attack this thing or do something? And of course, they all said no. So I was then left with basically the civil rights organizations, things like the ACLU, National Lawyers Guild. And the interesting thing is that at the very beginning, they said, well, we tend to do things that are real big, and this is real small. So that was a variation of no. So I had no other recourse but to walk over to the law library, open the first law book, and start studying the law so I could, in fact, do this myself, so I could represent myself, so I could proceed as a pro se or pro per litigant. And what essentially took place is over a period of approximately 8 years, representing myself, I first went to the state court, challenging the constitutionality of the ID law, and I lost. I then went to what would be the district state court of appeal, challenging the California ID law. I lost. I then went from the state system to the federal system. In other words, there's two different systems. There's state courts here. There are federal courts. Federal courts are big time. State courts are more or less small time. Went into federal court, district court, presented my case. I lost. Okay, then I went to the Circuit Court of Appeals. In this case, because it's California, it's something called the Ninth Circuit Court of Appeals. And the Ninth Circuit Court of Appeals was really the first court that took an intelligent look at the whole proposal. And I won. And that was, I'd been doing this now for 6 or 7 years, and that was the first time that I won. This is not an insignificant victory, because this particular law, this ID law, it was important for a number of reasons. For example, if you understand the Union of South Africa in the days where apartheid existed, you understand that one of the principal tools in segregating that community and oppressing the minority in that community was something called a pass law, which means that all the black people in South Africa had to have ID. They had to literally have an internal pass. And anytime they were anywhere, they had to be able to explain to the police authority what they were doing there, why they were doing whatever they were doing, and show them some kind of ID. We had in the United States, and in particularly in Southern California, the same kind of system. It was informal, that is to say, it wasn't written in law, but it was a practice. It was a sort of local Southern tradition. And this had been going on, and it had been like a black cloud over the day-to-day enjoyment of life, liberty, and the pursuit of happiness for anyone you talk to who was black, who was brown, or who was young. And of course, Southern California, that's a lot of people. This particular victory in the Ninth Circuit therefore had enormous ramifications to an enormous part of the population, the black, the brown, the young of that particular community. And because it's the Ninth Circuit, it was not only Southern California, not only San Diego, not only La Jolla, not only Del Mar, not only Imperial Beach, but it was the 9 states that make up the Ninth Circuit, which means California, Oregon, Washington, Nevada, Alaska, Hawaii, and maybe 1 or 2 more. It was the first time that the courts had really done something like this, in anyone's recollection.